We often think about crime in pretty simple terms, don't we? Someone does something bad, they get punished. End of story.
Yeah, but when you actually look closer, it's way more complex than that. There's this whole legal structure underneath.
Exactly. And today we're diving into the absolute bedrock of it all. Actus Reus and mens rea.
The guilty act and the guilty mind.
Right. Sounds simple enough on the surface, maybe?
You'd think so, but they're actually the foundation of almost all criminal liability. The prosecution, they generally have to prove both.
Both of them. Beyond a reasonable doubt.
That's the standard. And when you start comparing how they work in different places, like, say, England and India, well, that's where you find some really interesting complexities, even inconsistencies.
Okay, so that's what we're getting into. We've got some great sources, case law, legal analysis to help us unpack it all.
And the idea isn't just to give dictionary definitions, right?
No, definitely not. We want to understand how this stuff actually plays out, the real-world application and some of the maybe surprising wrinkles.
Sounds good. Where should we start? Actus Reus.
Yeah, let's start with the Actus Reus, the guilty act. What exactly are we talking about here?
So basically, Actus Reus is the external part of the crime, the physical bit.
Just the action itself.
Well, it's more than just like a physical movement. It could be an actual act, or sometimes it's not acting when you're legally supposed to an omission,
No.
or even just being in a certain state that's prohibited.
Okay.
And crucially, this action or inaction, it has to come from a voluntary movement, your own choice.
Ah, voluntary. So it's not just what happened, but also the context,
Yeah.
the result as defined by the law.
Exactly. Think about murder. The actus reus isn't just, say, pulling a trigger.
Right.
It's the whole picture. The conduct, the fact the victim was alive, and that the conduct caused their death.
Okay. And you mentioned omissions,
Yeah.
failing to act.
Yeah, our sources really highlight this. If you have a legal duty to do something, classic example, a parent caring for a young child, and you fail in that duty, like not providing food.
And the child is harmed because of it.
Yes, that failure, that omission, can be the actus reus. The sources mention the tragic baby starvation example to illustrate this point. It's quite powerful.
So the act can actually be not doing something. That's important.
Yeah.
And you stressed voluntariness earlier. Why is that so key?
Well, the law is generally interested in holding people responsible for their choices, right?
Sense.
So if someone, say, pushes you and you stumble and knock someone else over, injuring them, your falling isn't really the actus reus in that situation.
Because you didn't choose to fall.
Precisely. It wasn't a willed movement. It was forced on you. The sources draw a pretty clear line between, choosing to jump off something versus accidentally tripping and falling off it.
Okay, got it. So a willed act, or sometimes a failure to act when required.
Uh-huh.
What else makes up the actus reus picture? Any other components?
Yeah, the sources kind of break it down into three things. There's the origin, the thought leading to the physical action. Then there are the circumstances existing at the time.
The context we mentioned.
Exactly. And finally, the consequences, the outcome of the act. And what's interesting is that often it's those surrounding circumstances that make an act illegal.
Oh, so?
Like, just raising your arm is fine, obviously. But raising your arm while holding a loaded gun pointed at someone, suddenly the circumstances make it a potentially criminal act.
Right, okay. Circumstances are key.
And for omissions, as we said, it all hinges on whether there was a specific legal duty to act in the first place.
Okay, that clarifies the act itself. Now, let's switch gears to the why or maybe the how in the mind. Mens rea, the guilty mind.
Right, mens rea, the mental element. People often call it the guilty mind or evil intention, but honestly, it's broader than that. It's really the fault element.
The fault element.
Yeah, there's this really fundamental Latin maxim you see everywhere in the sources. Actus non facit reum nisi mens rea.
Which means?
Basically, the act doesn't make you guilty unless your mind is also guilty. You need that culpable mental state for most crimes.
But our sources mentioned this wasn't always the case, right?
Yeah.
Like way back.
Oh, absolutely not. In really early legal history, mens rea wasn't much of a thing. It was often strict liability, you caused harm, you were responsible. Intent didn't matter so much.
Just you broke it, you bought it, basically.
Kind of, yeah. But the sources show that by the end of the 17th century, certainly in England, the need for mens rea was pretty well established. It became a cornerstone of the law.
Okay, so it's crucial now. But what is this guilty mind? It can't just be one thing, surely.
No, definitely not. Mens rea takes different forms depending on the crime. Our sources lay out the main ones. First up, you got intention.
Intention. Like Meaning to do it.
Pretty much. Having a purpose, a desire to bring about a specific result. The sources use the case R.V. Steen as an example.
What happened there?
During the war, Steen helped the enemy, but his conviction was overturned because his real aim, his intention, was just to save his family who were being threatened. It wasn't actually to assist the enemy.
Ah, so his motive was different from his technical intention regarding the act itself.
Exactly. It shows the difference between intention, what you're trying to achieve, motive, why you're doing it, and also foresight, just being aware something might happen.
Okay, so foresight isn't the same as intention. If I know something might happen because of my actions, that's not necessarily intending it.
Not necessarily, no. That leads us to the next type, actually oblique intent.
Oblique intent.
Yeah. This is where the outcome isn't your main goal, your purpose, but you see it as a virtually certain or maybe highly probable consequence of what you were trying to do.
Okay, so you don't directly want it, but you know it's almost definitely going to happen.
Something like that. The courts have wrestled with this, Cases like Hyam v. DPP and later R. v. Woolen tried to nail down exactly how certain that foresight needs to be. It's a fine line.
Sounds like it could get very complicated in court. What else?
Then there's ulterior intent. This is where you do one act intentionally, but with a further specific criminal goal in mind.
With a two-step intention.
Kind of. Burglary is the classic example they give. Under one part of the Theft Act, you commit burglary if you enter a building as a trespasser with the intention to steal or commit GBH or do criminal damage inside.
So just breaking in isn't enough.
Not for that type of burglary, no. The Actus Reus is the trespassing entry, but the mens rea includes that ulterior intent, the plan to do something else illegal once inside. If you just broke in to get out of the rain, that specific intent wouldn't be there.
Gotcha. So specific intent, oblique intent, ulterior intent.
Mm-hmm.
What if someone just acts really stupidly or carelessly without necessarily intending the outcome?
That takes us to recklessness.
Recklessness, okay.
So recklessness is about taking an unjustifiable risk. The key question, and this has changed over time, is about awareness.
Awareness of the risk.
Yes. Our sources track this evolution. There was a period after a case called Caldwell where it was more objective, would a reasonable person have seen the risk?
But that's not the standard now.
No. The current approach from a case called RVG is subjective. It asks, did the defendant themselves actually foresee a risk? And was it, in the circumstances as they saw them, unreasonable to take that risk?
So it really focuses on what was going on in that specific person's head.
Exactly. It's a big shift towards subjectivity.
Are there other mental states? Like for theft, maybe?
Yes, absolutely. Dishonesty is a key one for theft. And it has its own specific kind of two-part test from the Ghosh case.
Okay, what's the test?
First, would ordinary, decent people think what the defendant did was dishonest? That's the objective bit.
Right.
And second, did the defendant realize that ordinary people would see it that way? That's the subjective bit. So it's a mix.
Interesting. A blend of community standards and personal awareness. It does seem like there's this constant push and pull between objective, reasonable person standards and subjective, what did this person think standard?
Totally. That's a major theme in the sources. The general direction is more subjective now, but there are definitely exceptions. And one more concept to touch on is transferred malice.
Transferred malice. Sounds dramatic.
It is a bit strange. It's basically where you intend to harm person A, but you miss and accidentally harm person B instead.
So your bad intention transfers from A to B.
That's the idea. The intent follows the act, even if the victor is different. The sources mention a case involving harm to a pregnant woman, where the baby later died after birth. The court applied the malice meant for the mother to the baby.
Wow.
But, interestingly, the judges in that case were quite critical of the whole doctrine. They called it a bit of a legal fiction, not really based on solid logic.
Seems like a concept that could cause some debate. Okay, so we've covered common law crimes. How does mens rea work with laws created by Parliament's statutory offenses?
That's a really important area. For a while in English law, it wasn't entirely clear if the mens rea requirement automatically applied to new crimes created by statutes.
So Parliament could create a crime without needing any guilty mind.
Well, the question was whether they had to specifically say if mens rea was needed or not. But a key case, Bren v. Wood, back in 1946, basically settled it.
What did it say?
It established that, as a general rule, mens rea is required for statutory offenses too, unless the statute itself very clearly says otherwise, or the implication that it's not needed is unavoidable.
So the default assumption is that you need some kind of mental element. Even if the law doesn't explicitly mention intent or knowledge.
Exactly. There's a presumption in favor of mens rea. Another case, Sweet v. Parsley, gave guidelines on how to figure out Parliament's intention when a statute is silent. You generally assume they meant some fault element unless there's a good reason to think otherwise.
But sometimes there are good reasons to think otherwise.
Yes. And that leads us neatly into strict liability.
Ah, strict liability. We hear that term a lot, especially with things like, I don't know, speeding tickets.
Yeah, that's a common area. Strict liability offenses are crimes where the prosecution doesn't need to prove mens rea for at least one element of the actus reus.
So you could be guilty even if you didn't mean to do it or didn't know you're doing it.
Potentially, yes, for at least part of the offense. Our sources give quite a few examples from case law. Things like possessing adulterated tobacco,
Okay.
selling alcohol to someone already drunk, that was Cundy v. Lecoq, or offenses related to pollution, like in Alpha Cell Ltd v. Woodward. Also, things involving dangerous drugs, or even acting as a company director when you're disqualified.
It seems to cover a lot of regulatory areas. Public safety, maybe?
That's often the justification, yes. The idea is that these laws regulate activities where mistakes can have serious public consequences, even if unintentional. Think food safety, environmental protection, road safety. They often involve what the sources call grave social evils.
So it's seen as necessary for the greater good, even if it feels harsh on the individual sometimes.
That's the argument. Proving intent in these areas could be incredibly difficult and might undermine the whole point of the regulation. It's interesting, though, to compare Cundy v. Lecoq selling booze to a drunk strict liability with another case, Scheres v. de Rutzen.
What happened there?
Similar area, licensing laws, but the court said mens rea was needed. The publican had to know the constable he was serving was on duty. So even in similar fields, the rules aren't always the same.
It really highlights that it's a specific choice made by Parliament or the courts for each type of offense. It's a trade-off, isn't it?
Absolutely. You trade off the principle of no liability without fault against the need for effective regulation or public protection, and figuring out where that line should be drawn is, well, that's the tricky part.
Is there anything even stricter than strict liability?
Yes, there's the concept of absolute liability, which is rarer. That's where no mens rea is required for any part of the offense. Very strict indeed.
Wow. And are there other general exceptions where mens rea just doesn't apply?
The sources mention some specific statutory offenses like historically waging war against the crown, also certain common law things like public nuisance, contempt of court, and various social welfare or regulatory offenses often fall into this category or strict liability.
Okay, that gives us a good sense of the English system.
Yeah.
How does this compare with India? You mentioned the Indian Penal Code earlier.
Right. So the interesting thing about the Indian Penal Code, the IPC, is that it doesn't actually use the term mens rea explicitly.
Oh. So the concept isn't there?
No, the concept is definitely there. It's just embedded differently. It's woven into the actual definitions of the crimes themselves and also into a whole chapter on exceptions.
How does it work in the definitions?
Well, the IPC defines offenses using specific words that clearly signal the required mental state. You'll see words like fraudulently, dishonestly, voluntarily, intentionally, knowingly used throughout the code. That language essentially builds the mens rea requirement into the crime's definition.
So the necessary guilty mind is spelled out for each offense.
For many, yes. And for some offenses that, you just can't really commit accidentally, like waging war or sedition or making counterfeit coins, the criminal intent is often just presumed by the courts. The act itself speaks volumes.
Makes sense. And what about these exceptions you mentioned? How do they fit in?
There's a whole chapter in the IPC, Chapter 4, called General Exceptions. It covers sections 76 to 106. This chapter basically works as a sort of negative way of dealing with mens rea.
The negative way.
Yeah, it lays out situations where an act that looks criminal is actually excused because the necessary criminal intent is considered missing.
Can you give examples?
Sure. Things like acts done by accident or misfortune, acts done out of necessity to prevent greater harm, acts by children under a certain age, acts by someone who's legally insane, or acts done by someone who was intoxicated but not by their own choice.
So instead of defining the required intent for every crime, they list situations where intent is legally absent.
Exactly. It's a different architectural approach, but it achieves a similar result, ensuring that people generally aren't punished unless they have a blameworthy state of mind.
Has the Indian Supreme Court weighed in on this?
Oh, definitely. The sources cite several key cases: Hariprasad Rao v. State of Maharashtra v. M.H. George, Natu Law v. State of MP, where the Supreme Court has repeatedly stressed the importance of mens rea in Indian criminal law. They've affirmed that it's a fundamental principle unless a specific law clearly and explicitly excludes it.
What was the Natu Law case about?
That involved a food grain dealer who was prosecuted for storing grain without a proper license. But he was acquitted because he genuinely and reasonably believed he had applied for the license and it was forthcoming. His lack of guilty knowledge, his honest mistake, negated the mens rea.
So despite the different structure, the core principle holds strong in India too. You need the wrongful act and the wrongful intent.
Yes, fundamentally, both systems require both actus reus and mens rea for criminal liability in most cases.
Okay, but hearing all this, the different types of intent, recklessness, strict liability, the objective versus subjective debate, the different approaches in England and India, it sounds like there must be scope for, well, confusion, inconsistencies.
Oh, absolutely. That's a major point in some of the commentary we looked at. Criminal law, especially in common law systems like England, hasn't always developed logically or consistently. It's often been piecemeal, responding to specific cases or problems.
Leading to a bit of a patchwork.
Exactly. There isn't always a clear overarching theory about when you use an objective test versus a subjective one, for example. This lack of a consistent framework can lead to anomalies.
Is there a push to fix that?
There has been. The sources mention Sir Henry Brooke, who used to head the Law Commission in England, strongly advocating for codification.
Codification, putting all the criminal law into one big organized code.
Precisely. The idea is to make it clearer, more consistent, more accessible. The Law Commission itself has suggested standard definitions for key concepts like intention, trying to bring some uniformity.
Because even established ideas get reinterpreted, right?
Yeah.
You mentioned recklessness changing.
Yeah, the courts themselves evolve their understanding. The shift from Caldwell recklessness to RVG recklessness is a prime example of the judiciary significantly changing a core concept.
And the highest court, the Supreme Court now, plays a big role, sometimes changing the law quite dramatically.
Yes, our sources highlight this tension. You have cases like RVR, where the House of Lords abolished the immunity for marital rape, a huge common law change reflecting societal shifts.
Right.
But then you have other cases, like R.V. Clegg on self-defense, where they were much more reluctant to change the established rules, even when reforms were suggested. So there's always this debate about how much lawmaking the courts should do versus Parliament.
And codification is seen as a way to create more certainty.
That's the argument from the Law Commission, yeah. They point out that many other major European countries have comprehensive criminal codes, which can lead to a more uniform approach. It aims to reduce the inconsistencies that arise from centuries of case law development.
So it's a really dynamic area. These fundamental ideas, actus reus, mens reus, they're not set in stone.
Not at all. They're absolutely fundamental, yes. In both England and India, you generally need both for a crime. But as we've seen, they're incredibly nuanced.
Constantly being debated,
Yeah.
interpreted by judges.
Exactly. And you have Parliament creating exceptions like strict liability for certain areas, often for reasons of public protection.
That tension seems key, the need for a guilty mind versus the practical need to regulate harmful activities effectively.
That's a perfect summary of the dilemma. It's a balancing act, and how that balance is struck keeps evolving with society and legal thinking.
It definitely gives you a lot to think about. It's way beyond just, did they do it? The why and how in their head is just as crucial most of the time.
Absolutely. It makes you look at different laws differently, doesn't it? You start thinking about whether the mental element required or maybe the lack of one in strict liability cases really feels right, feels just.
Yeah, like comparing a parking ticket, maybe, to something like assault. The role of intent feels vastly different.
It does. And it raises that bigger question. Does the current mix of subjective fault requirements and strict liability rules actually achieve the best balance between fairness to the individual and protecting the public? It's something worth pondering. Anyone interested could definitely look deeper into the cases we touched on or the whole debate around codification.
This deep dive has certainly shown just how intricate and frankly fascinating these core legal building blocks are. Thanks for walking us through all that complexity.
My pleasure. It's a deep topic.
So just to wrap up, we've seen actus reus, the act, and mens rea, the mental state, are pillars of criminal law. but they're complex, evolving, and applied differently across situations and even legal systems like England and India.
Yeah, with constant debate about intention, recklessness, and when society decides strict liability is necessary.
It really prompts you to think, doesn't it?
Hmm.
Consider laws. Where does the mental state seem absolutely vital? Where might the law work fine without focusing on it? Maybe look into some of those cases we mentioned, or the arguments for a clearer criminal code.
And the final thought to leave you with, perhaps, is this. As society changes, technology changes, are we sure the way we currently balance individual fault against public protection through these principles, is it still the right balance for achieving justice today?
Definitely something to consider.